Case number 06CR4471. Aggravated assault. Court appointed. I should have turned it down. But you don't turn down court appointments in Shelby County. Not if you want to stay on the rotation. And in 2006, I needed the rotation. The firm was 3 attorneys and a paralegal named Deb who'd been threatening to retire since Clinton's second term. Court appointments kept the lights on between the private clients who actually paid. So I took the case. Standard intake. Defendant's name was Marcus Pryor, 22 years old, broke a bottle across another man's face outside a bar on Lamar Avenue. Victim needed 40 stitches. Pryor had a prior for simple assault. None of this was remarkable. What I did next, that's where it starts. I pulled docket histories, every case, every time. It's not something most attorneys bother with, but I've been doing it since 1997, when a clerical error assigned me a case number that belonged to a child custody matter in Chancery Court. I walked into Judge Hammond's courtroom with a motion to suppress evidence in a drug case, and the judge looked at me like I'd lost my mind. He was hearing a dispute over visitation schedules. The case number on my file matched the one on his docket. Different courts, same number. Clerk's office said it was a printing error. That was embarrassing enough to change my habits permanently. Since then, I run every new docket number through the clerk's master index before I do anything else. Takes 5 minutes, saves you from walking into the wrong courtroom. So I ran 06CR4471. I got 2 results. The first was my case, Marcus Pryor aggravated assault, filed October 3rd, 2006, standard. The second was 71CR4471, State versus Barlow, manslaughter, filed September 14th, 1971. The clerk's office had been scanning microfilm all year. 50 years of paper docket cards going into the new electronic system. Duplicates were coming up constantly. Old numbers colliding with new ones because the numbering format had changed twice since the 70s. I'd seen 3 other attorneys grumble about it that month. Migration errors. That's all this was. But I'm a check-the-box attorney. Always have been. If there's a discrepancy, I note it. If there's a note, I follow up. If there's a follow-up, I document it. 26 years of practice, and I have never once left a loose thread in a case file. It's not virtue, it's anxiety. I filled out an interdepartmental records request for the original 1971 docket card. Dropped it in the tray outside the clerk's window on the 4th floor. The tray was cold metal, the kind that's been bolted to the same wall since the building opened. I didn't think about it again that day. The card came back 2 days later in a manila envelope with a routing slip stapled to the front. 3rd floor archives. Somebody in the basement had pulled it from the old filing cabinets they were emptying for the migration. I opened it at my desk. The docket card was yellowed. The typeface the old courier that every court clerk in Tennessee used before the IBM Selectrics gave way to computers. State v. Barlow, James Delbert. Manslaughter, 2nd degree, filed September 14, 1971. Defense attorney of record. The name on the card was mine, not a similar name. Not a common name that might overlap. My full legal name. First, middle initial, last. The same way I've signed every pleading since I passed the bar. I stared at it for a while. Coincidence. Had to be. Names repeat. Tennessee isn't that big. Somewhere in the early 70s, another attorney with my exact name practiced in Shelby County. Unlikely, but not impossible. Then I looked at the bar number. Tennessee bar numbers are assigned sequentially. Mine was issued in 1994, the year I was admitted. The number on the 1971 docket card was my number. 7 digits. Exact match. That bar number didn't exist in 1971. It wasn't issued until 23 years after this card was filed. The fluorescent light above my desk was doing that thing where one of the tubes flickers every few seconds. A quick strobe that you stop noticing until you're sitting very still and staring at a piece of paper that doesn't make sense. I noticed it then. I closed the file, put the docket card back in the manila envelope, put the envelope in my bottom desk drawer, locked the drawer, went home. Didn't mention it to Deb, didn't mention it to anyone. I should have left it there. Next morning, I told myself I was being thorough. That's what I told myself when I walked past my office and went straight to the records room on the third floor, where the microfilm readers were lined up against the wall like old television sets nobody had the budget to replace. I filled out the request slip. State vs. Barlow, 71 CR 4471, full case file. The clerk, a kid, maybe 23, summer hire, fed the reel into the machine without looking at me. The reader hummed and the screen filled with that bluish glow that microfilm gives off, the kind that makes everything look like it's underwater. The case was straightforward. James Delbert Barlow, age 34, white male, killed a man named Ronald Estes in the parking lot behind Midtown Tavern on Poplar Avenue, October 1970. Barlow claimed self-defense. Prosecution charged manslaughter, second degree. Trial set for February 1971. I scrolled through the file. Arrest report, booking photo, witness statements, 3 bar patrons, all saying different things. Standard. Then the defense motions. I don't know how to describe this part without sounding like I've lost my mind, so I'll just say it the way it happened. The motion in Lamine to exclude Barlow's prior arrest record, the structure of it, the paragraph breaks, the way the argument was organized, moving from the general rule to the specific prejudice to the balancing test. I've written maybe 200 motions in Lamine in my career. I have a template. Every attorney does. But templates are personal. The way you build an argument, the transitions you use, the specific phrases you default to when you're writing at 11 at night and not thinking about style, those are fingerprints. These motions read like mine, not similar to mine, mine. I scrolled to the deposition transcript. Barlow's deposition, taken December 1970. In the margin of page 14, there was a handwritten note, blue ink. The letters slanted slightly left, the way mine do. The lowercase g had that open loop I've never been able to correct since law school. It said, check Estes employment records, Shelby County Schools. I know my own handwriting the way I know my own voice on a recording, with that uncomfortable recognition that it's yours even when you wish it weren't. I kept reading. The case was dismissed. March 1971. Brady violation. The prosecution withheld employment records showing Ronald Estes had been fired from his custodian position at a county school for threatening a coworker with a knife. Prior violent conduct by the victim. Relevant to self-defense. Textbook Brady material. The defense attorney, the one with my name, had filed the Brady motion. I read it twice. The motion cited Kiles v. Whitley for the standard of materiality. Kiles v. Whitley was decided by the Supreme Court in 1995. This motion was filed in 1971, 24 years before the case it cited existed. In 1971, the controlling authority was Brady v. Maryland itself, decided in 1963. Every defense attorney in America knew that citation. The 1971 attorney, the one with my name, my bar number, my handwriting, cited a case that wouldn't be decided for another quarter century, and the judge granted the motion. Didn't question the citation. Case dismissed. I sat back, the microfilm reader hummed. The chemical smell of old film, that vinegar and dust smell that clings to your fingers after you handle the reels, was suddenly very present. I called the Tennessee Board of Professional Responsibility from the payphone in the courthouse lobby. Asked about my bar number. The woman confirmed it, issued to me, 1994. No prior assignment, no duplicate, no anomaly. I asked if a bar number could be reissued. She said no, sequential. Once assigned, permanent. Then I called the Shelby County Clerk's office. asked if there was a photograph on file for the attorney of record in 71 CR 4471. The deputy clerk put me on hold for 11 minutes. She came back and said yes. Attorney identification file, required for courthouse access badges starting in 1968. She offered to send a copy through interdepartmental mail. I said I'd come down. The photograph was black and white, 3 by 5, clipped to a card with the attorney's name and bar number typed beneath it. The face was mine, younger, maybe 30, thinner, but the jaw, the hairline, the way the left eye sits slightly lower than the right. My face. I was 3 years old in 1971. I put the photograph back in the file, walked to the conference room at the end of the hall, sat down. The vending machine coffee I'd bought was still on the table, cold now. I didn't drink it. I sat with the file and the photograph and did what I've done with every impossible thing in 26 years of practice. I looked for the rational explanation. There wasn't one. I went to the basement the next day, the physical file room, sub-level 2, past the boiler, through a fire door that hadn't closed properly since the 90s. The hallway smelled like humidity and old paper, that specific institutional decay you find in buildings that were built for permanence and then neglected into something else. The file room clerk was a woman named Mrs. Gentry. She'd worked in the courthouse since 1969. Everyone knew her. She kept the old paper records the way some people keep a garden, meticulously, personally, with an organizational logic that existed entirely in her head. I gave her the case number, 71 CR 4471, State v. Barlow. She didn't look it up. She walked straight to the third row of cabinets, pulled open a drawer, and handed me the file. "You worked that one hard," she said. I told her I wasn't practicing in 1971. I was 3 years old. She looked at me the way you look at someone who's made a joke you don't understand. Then she turned to the sign-out log on her desk, a green cloth-bound ledger, the kind with pre-printed columns. She flipped back, way back. The pages were brown at the edges. She pointed. My signature, November 12, 1971. January 8, 1972, March 3, 1972, April 14, 1973. My signature, 4 times, spread across 2 years, the same slant, the same open-loop G. "You came down here a lot for that one," she said, like it was the most normal thing in the world. I took the file upstairs, sat in my office with the door closed, read it cover to cover, every motion, every transcript page. 53 pages. The paper was brittle and yellowed, and it left a fine dust on my fingers that smelled like a library that's been locked for 30 years. The last document in the file was a motion for continuance. Filed by defense counsel, my name, October 22, 1971. The motion requested a delay in the Barlow proceedings because, and I am reading this exactly as it was written, counsel requires adequate preparation time for a matter not yet before this court, assigned under docket number 06-CR4471. 06-CR4471. My current case, Marcus Pryor, aggravated assault, filed October 2006. A motion filed in 1971 referenced a case number that wouldn't exist for 35 years. Pant, I read it 3 times. The typeface matched every other document in the file. The paper was the same stock. The filing stamp, the clerk's round ink stamp with the date, was consistent with other 1971 filings I'd seen. In the margin, the presiding judge had written a single line in pencil. Counsel's request is premature. Premature, by 35 years. I put the file down. I walked to the window. The parking lot below was empty except for my car and the custodian's truck. It was after 6. The strip lighting in the hallway outside my office hummed the way it always did. That 60 hertz drone that becomes the sound of every late night you've ever spent in a government building. My current case, Pryor, went to arraignment the following Tuesday. Standard procedure. The judge looked at the docket number and paused. Said it was flagged as a duplicate in the system. There was a prior case under that number. He asked if I was aware. I said yes. Microfilm migration error. He noted it for the record and moved on. Pryor took a plea, 18 months suspended. Case closed in 4 weeks. I never saw Marcus Pryor again. But the Barlow file, I asked the clerk to seal it, cited an administrative error in the docket numbering system during the microfilm to digital conversion. The clerk processed it without questions. They were sealing migration errors all year. One more didn't register. I kept a copy. Mrs. Gentry let me take the original motion for continuance. She didn't ask why. She just said, "You always did hold on to things too long." She said always, like she'd known me for decades. I passed the bar in 1994. She's known me for 12 years. She said always. The recorder is still running. Last box. I'm putting the Barlow motion in my briefcase. Not in storage, not in the sealed records. My briefcase. It's coming home with me. I decided to retire 3 weeks ago. Told the firm, told Deb, started packing boxes, standard wind down. 26 years. The motion for continuance filed in 1971 references counsel's final case. I didn't know it was my final case when it was assigned. I didn't know I was retiring when I took the Pryor appointment. I decided to retire after the case was closed. After. The 1971 motion knew it was my last case before I did. The briefcase clasp clicks shut. Heavy. Heavier than it should be for one piece of paper. I'm turning